today, I'm going to go through the most basic documents that we all need to make sure that our decisions and the things we want done get done when we're no longer able to stand up and object, basically. My name again is Steve Fogleman. I'm one of 3 judges on the Orphans Court for Baltimore City. On the front page, it says your Orphans Court judges. And it's got Judge Baylor Thompson, Judge Garrett, and Judge Lowenthal. Judge Baylor Thompson got a promotion, and she's now a district court judge. So she handles criminal matters and things like that. And I was appointed to fill her vacancy. Judge Garrett, in the middle, is now our new chief judge. He's got 19 years on the bench here in the city. He's a great guy. He practiced at the Billy Murphy firm. Just a great lawyer and a great gentleman. And then there's Judge Lowenthal, and she has been on the bench for 3 years, and she's also very, very qualified and good judge. So I'm happy to have joined them recently, and so they're going to be along a little bit later. Judge Garrett will be a few minutes late. Judge Lowenthal is actually hearing probate cases today, so I don't know if she's going to be able to be here, but we got to do our job. Somebody's got to be there to man the courthouse. So, nobody likes to talk about stuff like this. Nobody likes to talk about wills and dying or losing your ability to make your own decisions, write a check, or even pay the phone bill. But again, it's one of these things that a little bit of planning really does pay off. So the first thing we're going to talk about today are powers of attorney. In some respects, these are every bit as important as your will, because your power of attorney is a document that will allow the person you designate to cash your check, pay your bills, pay your rent, potentially rent out your own home, or sell your home. It's a person who stands in your shoes because you can't do that. You can't go to the bank and withdraw money. You can't sign a check. So it's a very simple document, this power of attorney, but it truly does allow who you designate to do anything you could do. They could sue somebody on your behalf, for example. So when we draft a power of attorney, we want to make sure you know exactly what you're getting into, because for years, too many people would hand these over to the youngest child, for example, and the youngest child might have had some problem or issue and would go and clean out mom's account without her even knowing until it was too late. So a couple years ago, the Maryland legislature changed the laws to make the document, the power of attorney, the ones the banks will now accept, make it very stringent and tell you, be careful before you sign this. You're reading, and I'm sorry, I'm on page 1 of the first section, power of attorney. This is a relatively brand new Maryland form. And you state your name, where you live, who you would like to make these decisions for you. But again, it says you should be very careful in deciding whether or not to sign this document. And so that language has been added because some people honestly didn't realize the very broad powers that they were giving away to the person that they had designated. So again, power of attorney is a document, and some people unfortunately are in assisted living, some people for years and years at a time, some people are unable to manage their own affairs for years and years at a time. People don't drop dead like they used to. People really, really do live on and on and on, but that doesn't mean they're able to manage their affairs. And so the best part about a power of attorney, and I'm telling you, you can make a photocopy of these pages and fill it out and get it notarized, and it is legal. You can go and see an attorney. I'm going to suggest some attorneys for you. I'm going to suggest a group that can help senior legal services with the city bar. But at the end of the day, the power of attorney, it's a fill-in-the-blank kind of situation. One size fits all. So this is one of the easiest documents you can fill out here. And you just need to find a notary, and grocery stores, post offices, notary services are available. So when you have this document, it has to be signed when you're still of sound mind. It's too late if you take it to your mother or your grandmother and ask her to sign it when she doesn't know what day it is, she doesn't know who you are, then it's void. So a power of attorney has to be signed when you're of sound mind, because later, when you are not of sound mind, that's when the people are going to need it. But you have to get it. You have to get it done while you're in a good state. So, as far as powers of attorney go, I'm trying to think if there's anything else, and I'll open up for questions on that. I think that's it. Does anyone have any questions on powers of attorney?
Yes, my name is Apple Trustee, and I'd like to know if the person is not of sound mind, then what do you do?
Well, then you cannot sign a power of attorney. And I'm glad you mentioned that, because one thing I did want to mention. A power of attorney can save you a lot of money as well. An attorney, even if you go to an attorney, might charge you $100 to draft this document. You can do it on the internet and print it out for $8.95. Put your name in there, get a friend, or if you're internet savvy, you can do it yourself. So it's a cheap document. But what happens is, if mom or dad or grandma or grandpa are already not of sound mind, they can't sign one. So that's why you get one for $9 now. Because if you don't, and then you need to take control of mom or dad's finances, okay, or cash his check or pay his rent, you have to file a guardianship with the circuit court, whereby you have to get an attorney, probably pay $2,000 down. Then the court is going to hire a second attorney to determine if your parent is of sound mind or not, and whether or not this guardianship should proceed. So you're talking $4,000 versus $9 on the internet. So as I said, some insurance is better than others. This is great insurance, and so I recommend it highly for everyone. You better make sure you trust your agent. You've got to trust your attorney. This isn't an attorney at law. This is an attorney in fact. This could be your husband. This could be your wife. This could be the best daughter you've got. This could be the best son you've got. But you've got to choose wisely, because this document allows them immediate access to your funds. Not once you're not of sound mind. It doesn't kick in after you've lost your sound mind. It kicks in immediately, as in, I can go right to the bank right now, even though you're fully able to drive your car to the bank and manage your affairs. That's right, and you would keep it in a safe place, and you would tell your loved ones where it is, and whether it be that file folder. I mean, I've had clients say, I keep it in that old blue suitcase at the bottom of my closet where I keep all my important papers in, and I write that down. And that way, if a granddaughter calls me and says, we can't find it, I'll say, well, why don't you check that blue suitcase? Yes, ma'am.
So once you just put your signature on that, if you want to undo that, you can't?
You can, but you would have to file a revocation of that power of attorney, and you would also want to get it to the bank and to your mortgage company and everything else, so that they know it's revoked, because otherwise somebody's running around and may be able to clean you out before you can stop it. Exactly. And that's easy. There's no form for that. You would just say, I, Janet Brown, do hereby revoke the power of attorney I granted to John Brown on March 14 of 2014, and then sign it, date it, notarize it, and get copies of that to everybody who might have your money still. Yes, ma'am.
Does this document have to be filed through the court?
Absolutely not. It's a private document, and so nobody needs to know who will be managing your affairs if you cannot. It's a family matter. So no, it gets notarized, it gets stuck in your drawer. You would give one of the notarized copies to your attorney, in fact, to the person that you're appointing. Now, and in that document, as in wills and in the healthcare directive, which I'm going to get into next, you need to, as I say, if one person, the person you appoint to do all these things for you, just says, you know what, I can't handle it, or just says, I don't want to do that, I'm not qualified to do that, I'm not in a place in my life, I don't have time, whatever reason, you have a successor agent, you have a backup plan, and that person would then go into action. So you'd want to give a copy of this document not only to the person you pick as your power of attorney, but as your alternate attorney, in fact, as well.
I have a question. I have heard somewhere down the line, like say for instance you assign somebody to be a power of attorney, say for instance, if you expire, they say then the power of attorney no longer has control.
That is correct. Thank you for mentioning that. The power of attorney loses all power once the person passes on. And so I like to call, for lack of a better term, power of attorney your will while you're alive. And then the will after you die is called a will. So that's exactly right. Yep.
One more, just one more. I want to know, can you put more than one person on that?
Absolutely. You can have co-attorneys, in fact, and a lot of people prefer that because it gives a veto. You know, if one person, something happens to their life, or they start making poor decisions, there's another person right there who can basically say, no, we're not doing that. We're not selling mom's house yet. She still lives in it. So that kind of thing. You select an agent, then you select a backup agent, and then it explains what your agent's rights are, and he has the right to consent or not consent to medical treatments which your doctors offer. He can decide who your doctor should be. He can decide where you should be treated, whether it be nursing home, hospice, or other facility. You can also designate that your agent will be riding in that ambulance with you. Even if you're completely unconscious, this will give the agent the right to be right at your side at all times. And of course, whether they're related to you or not, be able to visit you at any time. So, again, there's a section for people that your agent should consult specifically, where you put their phone numbers down so that the agent, the person you appoint, can give everybody information more than anything. How is grandma doing? And then there is a long checklist starting on page 5 of 8 about what you want. And you're going to specifically check things like, in the situation when I'm in a persistent vegetative state, do I want to be fed? Do I want to be hydrated? Do I want pain medication? Do I want you to let me die? Effectively. So, then there's an organ donation section. Now this has to be signed by 2 witnesses, and I believe it still has to be notarized. And I'm almost positive it still has to be notarized. And then there's a part about donating your body to the State Anatomy Board, but it's much more comprehensive than it used to be. It used to be about as simple as a power of attorney. Just say, this person can do whatever they want for my medical needs. And so that's changed.
So the witnesses cannot be someone who inherits.
That's correct. And I thank you for saying that. You understand why, right? Because you don't think it's going to happen, but you wouldn't want to even think there was a chance anyone would take steps not to prolong your life just so they could get into your estate. So, I'm getting 10 grand from grandma. That should not have any bearing on my job as the healthcare agent for grandmother's health. So, and that's exactly right. For those who just came in, got a booklet for you. How you doing? All right. You can never be too young to plan. Nice to see you. All right. So, now we finally move on halfway into the program. It's what you all came to see. Will drafting seminar. So we're finally there. Now a will is the only document, and I might have to change my thinking, because I'm going to find out if the healthcare directive has to be notarized, because I've always been under the impression back in the 80s and 90s, old school, was the will is the only document that doesn't have to be notarized. And that's because they want to be able to allow people to execute one in dangerous situations. Soldiers on the battlefield. Where's he going to find a notary? Right? Okay. So he's got 2 buddies though, and they can sign, and he's got a will. And so wills mean many things. You can pay an attorney thousands of dollars to do a complex will with a state with all sorts of trusts therein to get money to their children, avoid taxes basically. But a will is really at its heart, is a very simple document. And the courts will accept almost anything, as long as a few simple rules are followed. The first rule, as I said already, that has to be followed, it's got to be signed by the testator, that's the will maker, and it's got to be witnessed by at least 2 witnesses. And the witnesses have to say, I was there. And so there's a thing called an attestation clause, and all it says is, Mr. Johnson signed this will in our presence on May 30th, 2014, and we were there. And then, if you really want to make it even stronger, you say we were there, and he appeared to be of sound mind when we were there. And so that right there, signature, 2 witnesses stating they were there. That's 99% of a will. And that's really what the court is looking for, to make sure that we can say, yes, that's a good will. The rest of it's up to you. It's like pizza. You put on it what you want. And if you want to just give everything to your son, to your 2 sons, that's fine. If you want to give $1,000 to the Goodwill in North Baltimore, you can do that. If you want to give your diamond brooch to your granddaughter, you can do that. So it's very, very individual. It's completely up to you. It's about leaving memories and sharing with your loved ones in the way that you want to do it. So, but now, having said it's a pretty simple document, there's a lot of details. The devil's in the details. So, you have a statutory share in Maryland where if you're married to your spouse, and especially if you and your spouse have kids, you can't cut her out of the will. You can try, but that's when she comes down to the Orphans court and gets it all straight. So you can't do that. Now you can, however, cut a child out, an adult child out, somebody that you don't believe, has lived the life that you believe he or she should live. And so what happens, so if you cut, say you have 4 kids and you cut one of them out, that kid might go hire a lawyer and say, oh, mom forgot about me, so I should get a quarter share. And so then that has to go to court. In the end, you probably won't get the money. But the best way, or a way a lot of people do legally, effectively cut somebody out of the will, is to say, I have 4 children, John, Debbie, Sam, and Adam, and I leave John, Debbie, and Sam $99,999, and I leave John $1. That way you didn't forget about him, you were thinking about him. Sure.
Because if you don't do it that way, then that one person that you didn't leave anything to take to court. Get up to,
Right. So you don't have to leave him $1 necessarily. You can say, I have another son, John, who I am not leaving anything to under this will. And so you hope you never have to do that. I mean, you really do. So, but this is your wishes. And if the thought of him spending $10,000 with his girlfriend doing whatever they're going to be doing, if that's something that's going to make you roll over in your grave, you're going to do it. And that leads me to another topic on wills, which is when you leave your share to your children, you have to decide, or your heirs, you have to decide whether or not you want to leave the money to your child, whether or not he or she dies before you. And what I mean by that is, if you leave, you usually want to say, I leave my money to my 2 sons if they survive me, 50% each. If they do not, if one of them predeceases me or the other, then the one remaining son gets everything. You can do it that way. But say your son has 3 children with a nice woman, and you say, you know what, I'm going to keep his share per stirpes, and it's a Latin term, but basically by right of representation, saying, I have 2 sons right now, and even when I die and my will's distributed, and I only have 1 remaining son, I'm giving it to my son, and I'm giving it to my son's estate, so that his wife and kids will get his 50% share. Now, if you don't like, let's take the kids out of it. You can't stand her husband. You might not like the idea of half of your estate going to your son-in-law, right? So that is, in that case, you want, if he survives, you want the first child, the surviving child to inherit everything. So as I say, these are all things that have to be decided based on your loved ones and the loved ones that you got stuck with as family, but you still got them. And it's your money, and this is your chance. This is your chance, seriously, to make it the way you want it. And this won't even be effective until after your death. But this is one way, you can still have some control from the grave. All right, so
how often do people make their wills? You know,
People,
sometimes they decide they don't like them after 20 years, and they decide they're gonna change their will to,
people make wills after life-changing events. The biggest life-changing event is having children. The second most life-changing event that I got will business from is divorces. The last thing you want to do, I mean, and there's a lot of people who are separated and waiting for divorce, and their will says, I leave everything to John Tyler, and I'm about to divorce John Tyler. So that's a big, big life change. That's when you pull him off that's when you pull him off the life insurance policy and in your 401k and things like that as well. And since I brought that up, a will gives away all of your property that isn't automatically given away by another means. When we talk about an estate, we talk about all the property that's just in your name that we can't do anything with until it's distributed. But a lot of property won't be part of your will. For example, if you own a house as joint tenants with rights of survivorship, as almost all married couples do in Maryland, tenants by the entirety is what they call that. That house automatically passes to you upon your spouse's death. No will required. It instantly becomes yours, okay? Now, if you want to sell that house and put these proceeds into the will to be distributed to your 4 granddaughters, then we need to specifically say, you need to literally change your deed possibly, and that's the thing. If a husband and wife are together, the husband dies, now the wife owns the house outright. Then, since it's only in your name, then the house will go into your estate. Do you understand what I'm saying? But as long as there's somebody else on the deed, and this is another thing that people do to avoid estate tax, is they will put they have 2 sons, a widow has 2 sons, she will change her deed to make it so that the 2 sons come onto the deed immediately as partial owners and with rights of survivorship, so that when mom passes, the boys automatically own the house.